4 years, 3 months and 16 days ago, I stood in this very place and delivered my inaugural speech. In the President's Gallery sat my wife, my son and my daughter. Nobody saw my daughter at the time. I didn't even dare mention her in my speech. But on that day, my wife was 5 weeks pregnant and she was not sitting there alone. After having 2 unsuccessful pregnancies, 1 ectopic and 1 ending in miscarriage, my wife and I have experienced the fragility of life in its formation, the tragedy and the heartache that it brings. We had just that morning had a scan and seen Colette's perfect heartbeat, and were filled with optimism that we would add to our family. As appalling as some may find it, a heart beats at 4 weeks. Thankfully, I have the freedom to say that in this place, even if it can't be said on a bus. In my inaugural speech, I said, together Penny and I have created what will always be our greatest achievement, our son Christian, whom I love more than words can describe. I hope and pray that he can never be alone. Those prayers were prayers for our daughter Colette, the hope that she would develop in the womb and join our world as a happy, healthy, smiling, albeit screaming, baby. 2 months later, we went on holidays. Our photo frames around the house highlight those pictures, and Colette will always ask, "Where am I?" And she answers her own question. I know, I was in Mummy's tummy. And she's right, Mr. President. It wasn't an organism, a clump of cells. It was her, our Letty. It was during that trip, laid up in the hotel at 14 weeks gestation, that I felt Colette's first kick and realised for the first time the little dancer she was to become. My wife had felt flutters much earlier. Her personhood started in the womb. That, Mr. President, is the miracle of life, a miracle that all of us sitting here in this chamber are the product of. Both of our children were born premature. Christian at 35 weeks and 1 day, Colette at 35 weeks and 2 days. They both spent a week in neonatal intensive care, with problems with their breathing and sighs, leading the paediatricians to plead with us to never to do this to them again. Both were delivered by Caesarian. I cannot see how the status of their personhood changed from their position in the womb to into the world. They may have relied on the umbilical cord in the womb, but they were still people. I believe in their innate rights as human beings in the womb and in the world. I believe they have the right to life and that others, the most vulnerable in our society, deserve that protection too, which is why I cannot and will not support this bill. Proponents of this bill push the cash phrase, "My body, my choice." They claim that it is a woman's right to choose. It has been said that men cannot proffer a view on this matter. So it is not my view that I proffer, but rather my wife's, a feminist and a woman who has been pregnant 4 times and carried 2 children to birth. These are the words and experiences of my wife, Penny. I'm a feminist and I'm pleased to be a woman because of all that women can achieve. I grew up believing and fighting in the belief that girls can do anything. It's true we can. I thank the feminist movement for progressing the rights of women, that we aren't just baby-making machines. It's something I fought for throughout my life as a mother and a working mother. The feeling of pregnancy is different for everyone, but most common in my experience of discussing motherhood with others is that feeling of carrying life. When I was 15, a friend who I was born 4 hours apart from in the same hospital had a baby. It was a total shock at the time, but I vividly recall her talking about the fact that she knew she was pregnant even before it was confirmed. She said she had a sense of responsibility over her body, which she had never felt before. She mentioned that walking across the street was now a much more measured process of assessment of risk to protect more than her life. I remembered this, but didn't understand this until I fell pregnant myself. Many could view at that age of 15, below the age of even legal consent, she should have considered an abortion. Instead, my friend, back then, talked about the life and the life that was living inside of her. My journey to understanding the benefit has been a long one, and a journey I truly only appreciated when I became a mother myself. Having had 2 children, though, seeing their baby image, feeling their kicks, I cannot separate out that these unborn children are in fact human lives. Mr. President, some may deride my position as that of a Christian conservative. I have religious belief. I've stated that in this House from the moment I entered. The truth, however, that I acknowledge and do not shy away from the fact that I have, is that my views on this matter are more shaped by fatherhood than by religion. Seeing the first scan of your child, feeling their first kicks, watching them in their 3D scan and recognising that face from the womb when they enter the world, screaming and bloody. And of course, hoping and praying at every turn for their survival, truly and purely appreciating the miracle and fragility of life. Having children is an immense honour and privilege, and it is a responsibility as well. For many who have undergone abortions, their perspective is changed entirely when they do choose to fall pregnant. From those that I know that have had an abortion, every one of them have told me that their views on the matter changed entirely after they delivered a baby into the world. Many have believed, like those that have suffered miscarriage, that the soul has carried over to the child that they have borne. Mr. President, I want to outline that I do not pass any judgment on women who find themselves in the invidious position of an unplanned pregnancy and choose to have an abortion. I know that it is not a choice that most people take lightly, and it shouldn't be one either. I've known people who have undertaken abortions, and none of them have undertaken the procedure and not been concerned by the decision, either at that time or later in life. The member for Mulgoa in the other place, a former Minister for Mental Health and Minister for Women, has eloquently outlined in her contribution the psychological impact that abortions visit on women. As a society, we need to do better in providing support to these women and demonstrating that there are other options available. There is support available to continue a pregnancy, whether that be in keeping the baby or whether that be in putting the baby up for adoption. Unfortunately, our system at present is a single track that will provide the world for wanted babies and pushes a track of only abortion for those babies that are unwanted. This bill will only enforce that track. Much has been said in this place and the other place about the stigma of these procedures being included in the Crimes Act. Mr. President, there is no evidence that has been provided from other jurisdictions with similar legislation to the one proposed here that there is a reduction in psychological harm that stems from such a legal move. The only measure by which we can reduce the psychological harm is by reducing the number of abortions that are undertaken. There are 80,000 undertaken in Australia, and I've heard estimates in this place and the other from proponents of the bill outlining that there are anywhere between 20,000 and 38,000 that occur in this state, which is why we need a requirement for data in this bill, which I foreshadow I'll be supporting amendments to on the committee stage. Mr. President, I quote from the story of a father who outlined his daughter's pregnancy at 18. He writes from his experience. I also remember taking her to the doctor to get the results of her blood test. I will never forget how the female doctor, who also had a daughter of the same age, tried several times to convince her simply, take this tablet and it will all go away. My daughter said with conviction, I made one mistake. I will not make another. The doctor stared at us in disbelief. I'm so very proud of my daughter and her decision to keep her unborn child. Her dreams of becoming a school teacher are on a hold now, a small sacrifice so she can put the life of her son before her own. Mr. President, that accords similarly to the experience my wife had when she was 20 and supported a friend through an abortion. These are not words of mine, but words of my wife Penny. At the time, I did not have a concept of what was really inside of her. I remember the referring doctor describing to the pregnancy as merely cells. There were no other options presented except for abortion. I recall being in the waiting room with a range of different people. One woman there with her father urging her to go through with it, one with her boyfriend, and I can recall a woman sitting quite casually as if to divorce herself from the whole room, flicking through a magazine. I've often thought about this time and the support I gave my friend as society's failure to support her as a woman. I say this now having had my own children and to know what it feels like to have a living being inside of me at 12 weeks. Mr. President, some proponents of this bill have justified the bill's short passage through this place on the basis that there has been 119 years for people to make up their mind on this legislation, and everyone already has a view. The proponents of the bill have said that there are no complications in the bill, none. It is simple, it is straightforward. We've been told, for those arguing for amendments to the bill, I say categorically, those amendments are not required. Well, Mr. President, through the amendments moved by the bill's co-sponsors in the other place, we have already seen that that simply is not the case. I concede, Mr. President, that there is community support for the decriminalisation of abortion. If this bill simply did that and codified the existing arrangements, then community opposition would not be so widespread. I'll even agree with the polling commissioned by the Greens that found 73% support for this proposition. I want to state that I'm open to abortion being dealt with outside of the Crimes Act. I and most members of this place who are opposed to this bill have not sought to change the current arrangements. This bill is not simply codifying the current arrangements. It is not just correcting a clerical error. The public doesn't see abortion as a black and white argument. They have a fairly complex view on where laws surrounding abortion should sit, and they don't fit neatly in either a pro-life or pro-choice characterisation. Polling undertaken by Galaxy, commissioned by Abortion Rethink, shows that there isn't support in New South Wales for the following, Mr President. 74% do not support late-term abortions past 23 weeks, 60% oppose mid-term abortions past 13 weeks, and 83% oppose sex-selective abortions, all of which are allowable under this bill before the House. Mr President, here's what the people of New South Wales do support. 61% support conscientious objection, 80% support a 2 to 3 day cooling off period, and 90% believe a woman should have the right to independent counselling from a source that has no financial interest in her decision. None of these are captured sufficiently in this bill, and I foreshadow that I'll be moving and supporting amendments in the committee which attempt to address some of these failings. There has been no overwhelming public sentiment crying out for this legislation in such a manner, Mr President. 48% of people in New South Wales believe that the current law is about right. There are only 16% who believe that the current law is too restrictive. The proponents of this bill like to describe this legislation as archaic, a regime of a 119-year-old act. Well, if that's the argument, we'd better throw out the entire Crimes Act of 1900. And let's not forget the Constitution Act of New South Wales of 1853, which is now more than 166 years old. It is a furphy to say that this law is 119 years old, and that a woman or a doctor can be held liable for a criminal offence for procuring or performing a termination. If that were the case, Mr President, my wife could have been held liable for an offence in undergoing a termination with our first ectopic pregnancy, where she had to go 2 rounds of methotrexate. The truth of the matter, though, is that since 1971, the law in this state does not prohibit abortions. What the law does is prohibit unlawful abortions, and the test as developed from the decision in Wald or the Levine decision, which held that a lawful abortion required the consent of the patient, that the termination was skillfully performed by a qualified medical practitioner, and that the termination was necessary to preserve the woman's life, physical or mental health. CES and Superclinics Australia in 1995 further expanded the definition of health to allow for the consideration of economic, social and medical circumstances during or after the course of the pregnancy. This is a fairly liberal regime already, which is why there is no overwhelming public call for laws surrounding abortion to be further liberalised in this state. This legislation does far more than simply codify the current arrangements, which is why it opens the door to abortions on the grounds of sex selection and disability, purely because an abortion can be undertaken for any reason or no reason at all under Section 5 of this bill. You would think if you were simply decriminalising abortion, you would pick up and implement the current restrictions that are opposed at common law. But rather, this is all dispensed with under this bill for terminations of less than 22 weeks gestation, which is, Mr President, more than 5 months. While terminations in New South Wales under New South Wales Health Pregnancy Framework for terminations in New South Wales Public Health and organisations are assessed with respect to 3 classes determined by the age of gestation, those being less than 13 weeks, 13 to 20 weeks gestation and more than 20 weeks gestation. This is not reflected in the bill, which only differentiates between terminations at less than 22 weeks and greater than 22 weeks, an arbitrary line that picks up practice in other states and not the current law or framework in New South Wales. The community has significant concerns about the prospect of late-term abortions, as do I. Where terminations after 22 weeks are permissible in other jurisdictions globally, they are largely matched with very restrictive conditions. In this legislation, the restriction around abortions after 22 weeks is only that they are performed by a specialist medical practitioner with a consultation of one other, and that they consider all relevant medical circumstances, the person's current and future physical, psychological and social circumstances. This, to my mind, Mr President, is not a sufficient standard for the termination of a fetus, which is of viable age. I say that because there are babies that have survived at less than 22 weeks. Terminations at such a late stage of pregnancy should be governed by much stronger restrictions. To pick up on the terminology of the member for Pittwater and the other place, there are growing and competing rights of the mother and unborn baby as the gestational age increases. This is not a sufficient restriction to pick up those rights of the unborn child. I'll be supporting amendments to try and improve this bill in regard to increased restrictions around late-term abortions, to constrict them only to situations where it is necessary. Under this bill, Mr President, there is no criminal sanction for any medical practitioner. They are completely excluded. I can understand why that is the case in the performance of a termination within the remit of the legislation, but they are immune from any criminal penalty under this bill. This means that a medical practitioner can undertake a termination on a woman without complying with the terms of this bill, such as something as grievous as not gaining consent, and bear no criminal penalty. Criminal liability under the bill in Division 12 only attaches to the termination of a pregnancy performed by an unqualified person. Any common law offences are also extinguished by Schedule 2(4) of this bill. These are provisions, Mr President, that do nothing to protect vulnerable women. Mr President, I turn now to another significant objection and concern I have with this bill, and those are the provisions that relate to conscientious objection of medical practitioners. I have had medical practitioners contact me with respect to the provisions in the bill. Those have ranged from obstetricians, gynecologists and general practitioners, expressing concerns with these provisions. These practitioners have told me that they believe the requirement to refer to a medical practitioner that they believe will perform an abortion will make them complicit in the process. I quote here from the submission of the Christian Medical and Dental Fellowship of Australia to the Social Issues Committee inquiry concerning Clause 9 of this bill. I quote, "Many practitioners with conscientious objection to abortion would agree that effective referral would make them complicit in the act, therefore removing any right of conscientious objection from this bill. This clause should be deleted. It is recommended that the legislation only require healthcare practitioners to respectfully inform patients about their conscientious objection and inability to refer for abortion. With no further requirement to act, healthcare practitioners with a conscientious objection to abortion should be protected against professional disadvantage as a result of their conscientious objection." Mr President, we've heard many members talk about the AMA submission. When you look at who will be raising conscientious objections, I would have thought that the Christian medical practitioners would be the ones that you would turn to first to see that their fears with respect to conscientious objection were actually realised in this bill and that their concerns were taken into account. GPs in particular, Mr President, have expressed that concern to me as well, as they believe they are the most exposed in this case under this legislation. I'll be supporting amendments similar to those moved by the only medical doctor in the Parliament, Dr Joe McGurr, to address these concerns. Mr President, I want to take the opportunity to thank all of the communities across New South Wales, particularly communities of faith, that have mobilised and expressed their position on this bill. We have seen with Honourable Robert Borzak this morning upping the numbers. I think, to my mind, so far more than 80,000 petitions against this bill lodged in this place. This is a piece of legislation that was sprung on the people of New South Wales, and it is my belief that the urgency with which the process has been embarked upon has further fuelled passions and grievances in this debate, and further fuelled a feeling of isolation from particularly religious and faith communities across New South Wales. Not to mention, Mr President, the limited time with which people have had to examine and have input into a bill of this gravity. I'd also like to particularly pay thanks to Liberal members who've contacted me on this bill, Mr President, both who've been opposed and supportive to this bill. Whatever their views, I've appreciated their feedback, and as their representative in this place, in line with the views espoused by Edmund Burke to the electors of Bristol, I owe them not just my industry, but my judgment. Mr President, that judgment leads me to oppose this bill, and I implore other members of this place to do likewise.